4:30. So this is Google Microsoft 2.0? The panel is sponsored by the Center for Business Law under the leadership of Julia Kostritsky and the Spangenberg Center for Law, Technology, and the Arts under the leadership of Craig Nard. In terms of thinking about the panel, we're going to be thinking about how exactly big tech actually ends up intersecting with antitrust law. Think about that in terms of the current litigation that's going on in regard to Google, but at the same time, we are going to out and think about antitrust generally through the wisdom of Price, who teaches antitrust. We're then going to focus on the specific case and put it in the context of the Microsoft opinion that happened about 20 years ago and really change how the internet functions through the wisdom of Professor Ray. And then finally, we're going to think more generally about the question about how antitrust should intersect with big tech, and we'll hear from Professor Anat Allen Beck. So the resumes are online. If I read them all, they would take a bunch of time, and I feel like we should dedicate it to the actual panel. So I'll let Rita kick things off. Take it away, Professor Price.
Hi, thanks for coming on this dreary day. So I have a little slide presentation. But basically what I want to do is explain to you just the basics, the ABCs, a little primer on antitrust law as opposed to specific, I just want to do a little primer on antitrust law as opposed to specifically how it applies to tech to give you some sort of background on that. So these are the statutes, these two statutes enacted in 1890. That's the Sherman Act. Section 1 is all about conspiracies and fixing prices and things like that. And Section 2 is all about monopolies. And there have been many laws that have been enacted that are antitrust laws since then. But basically, this is 90% of antitrust law. These essentially two sentences. And so the first sentence talks about the fact that every conspiracy and restraint of trade or commerce among the several states is declared to be illegal. And then it talks about the fine. So if you violate this law, what's your fine going to be and what's your prison sentence going to be? And so that's Section 1. That's about conspiracy. Section 2 is about monopolies. So anybody who attempts to monopolize or monopolize also could be subject to criminal penalties. So a couple of things, as far as I know, except as maybe as in a RICO case or something like that, nobody's ever been criminally charged with monopolizing. But there are certain things, certain behaviors that you can commit in Section 1, conspiracies, where you can be criminally charged and you can go to jail and you can pay big fines. So this is the whole basis, just these two sentences of our competition laws in the United States. And ever since these laws have been enacted, we have been trying to figure out for 220 years what these words mean. So this has been a really evolving area of the law. Particularly when you look at it, restraint. What's a restraint? Well, being hyperbolic, if you are a car dealer and you only have 10 cars and 11 people want to buy cars, well, that's a restraint because you aren't selling that car. Or maybe you're a bank and, people want to come in and get loans, but you're not giving them loans because maybe they don't have a good credit rating. So that's a restraint. So the courts have been trying to figure out for years what a restraint is. Similarly with monopolies, we've been trying to figure out what it means to monopolize. So you can't just be big. You can't be prosecuted or sued just for being big and providing products. There has to be something more to that behavior. Similarly with attempts to monopolize. What is that about? So some of the key concepts, can you go to the next one, Rob? Around antitrust law have to do with these terms horizontal and vertical. This slide is intended, it's not perfect for this, but it's intended to show how we look at antitrust violations or antitrust or anti-competitive behavior based on the position you're in as a competitor, as a company in the marketplace. So we see on the right side that we have companies that are, we call this horizontal. So these companies are direct competitors. They're all big or small. They're all the companies that make the same thing or sell the same product or do the same service. And when those companies get together and talk, or when those companies get together and decide that they're going to merge, we're more concerned because those people in a horizontal position to each other, entities, companies in a horizontal position to each other, can have market power. And when you have market power, you can control prices. If you have market power, theoretically, you can enact a price increase and keep it there because there's not a competitive entity that can challenge you. So that's why we're concerned about monopolies and market power. On the left side, this is what we call vertical behavior. So, going from, I think of the oil companies. So if you produce the raw material and then you customize the product and then you distribute the product and then you sell it at the gas stations, that's like the supply chain. So if you control that whole supply chain in an industry, that's a lot. And maybe there'll be different entities that are not, that you don't control. You might want to acquire those. But we're not as concerned about that because those entities, that oil company and that oil refiner and that gas station, they aren't direct competitors. So when you hear antitrust law discussed, it's a lot of times it's about whether it's vertical or horizontal. And those two, those dimensions, horizontal and vertical, are treated differently. So in a horizontal context, where there's price fixing, we might charge a criminal prosecution. In a vertical context, you might dictate to your, so suppose you're selling, I don't know, fashion, you might dictate to one of your distributors, a store, boutique, you have to have this minimum price. Well, that's price fixing, but we're not as concerned about that because there might be some economic efficiencies around that. Can I get to 3, Rob? Thank you. So I just wanted to outline this for you a little bit about the differences between these two. So like I said, Section 1 is about 2 firms. It's all about an agreement. So did you agree to fix prices? Did you agree to not bid against another company to keep the prices up? And the way Section 1 is parsed out is there's restraints, and this has evolved, like I said, over the years. There's restraints. We're trying to figure out what that word restraint means, right? And so there are restraints which are not allowable. There are restraints that we are willing to prosecute criminally. So the restraint is agreeing on price. So if you agree on price, or if you agree on how much you're going to produce, if you agree on output, that's a horizontal agreement. That's what the courts have referred to as a naked agreement. So the only reason you have the agreement is to get more money, is to fix prices, is to destroy competition. And so that's how the law is parsed out over the years. When looking at restraints under Section 1, when you're looking at what 2 or more companies do together, we're trying to figure out if the purpose is to destroy competition or to promote competition. So this area of the law is viewed in 2 different ways. So initially, the per se rule, that is, if you have this kind of agreement and it restricts price or output, that's all we need to know. We're not going to let you explain why that was a good idea, because our concern is that's a destruction of competition. But if you have a different kind of agreement, and the agreement is really to promote competition, and a lot of times what I was talking about in terms of these vertical agreements might be agreements to promote competition. Now in Section 2, we're just talking about 1 firm, okay? And what we're concerned about is market power. And when a single firm like Google engages in certain agreements so that they can, make more money, be more competitive, produce more products, we're concerned when they have market power, because they might come to be in a position where they can control the prices and keep them up artificially, way above what a competitive level would be if there were a competitor out there. So when we talk about monopoly, we look at whether you have market power. There's not really any way to know if you have market power, but we can see if you have market share. And if you have a really high market share, like Google in this case, like Microsoft, still, then you probably have market power. But that's not enough. We have to drill down a little bit more. We have to define what the market is and what is Google's market. What are all these tech companies? What is their market? It's very hard to define, especially when you look at an Amazon. What's their market? Everything that you sell, or is it something less? And as we define the market, we define it by what the product is and where they operate. So if we can just go to the next slide. Oh, we are on the next slide. Okay. So basically what I was saying about the per se analysis is we look at whether there's a horizontal agreement, and if you've got this kind of agreement to fix price or reduce output, that's enough. There's no defenses to that agreement. You can't bring in how things are more efficient this way, how you're really going to, it's going to benefit consumers. The agreement is the violation in itself. So the way antitrust law has evolved is that, we feel like initially there was a sort of a, we want to be very competitive. We want to have a lot of firms out there. It's 1890. We want more people to compete. And, so maybe we want to promote more small business. But the development of the Chicago School of Economics and during the Reagan administration, that kind of changed to, well, it's really beneficial to consumers if you have the lowest possible prices. So as long as a restraint is efficient and results and will likely result in lower prices, then that's allowable. So that's been sort of the philosophy until this administration, where this administration is looking at some situations, and the previous one to some extent, where we have such powerful entities that were more concerned that efficiency may not be the only key. And when I say we, I mean generally. Okay, and so I'll just quickly, so that's the per se view of Section 1. And Section 1, the rule of reason is we do some of the same things to analyze whatever the conduct is that we do in a monopolization context. We look at what's the product market, what's the geographic market, and is this going to help consumers? Is it going to benefit consumers, or is there some other way you could benefit consumers that wouldn't be so restrictive as the restraint you want to impose, like resale price maintenance, where you tell a retailer they have to charge at least this much or they can't sell your product. So let's get to monopolization. That's the next one. Is that it? So, as I was saying earlier, to be charged with monopolization under Section 2, you can't just be big. You have to actually do something. So we first have to define the market to determine if there's market power, and if those things are true, did you Google go out and get that market power willfully to be anti-competitive, or were you just somebody who was, you just naturally grew historically and you have a superior product and great business acumen, and so those are the two sides that are arguing right now. So that's the Justice Department versus Google. People just like us. We have great products. The Justice Department's argument is basically, you've done a lot of things to prevent other people from competing with you. A lot of what we call exclusionary conduct. And I don't think we have any issues on attempt to monopolize at the cases we're looking at today, but similarly, when you attempt to monopolize, you have to, there has to be proof that not only you were trying to get big, we have to show that there's a market, what the market is and market power, but you have to show a very specific attempt to monopolize. You can't just be getting bigger, and you have to show some sort of anti-competitive conduct. What we usually hear is predatory pricing. So the idea that you're pricing really low so that you'll starve the other competitors out of the market, and then you'll get to be a monopoly. And not only that, with an attempt, if you're going to make an attempt charge, it's not something that's actually occurred, so you have to show that there's a dangerous probability they're actually going to succeed at that. I just put in a little section of the Clayton Act to show you that there have been laws that support these two laws over time. So the Clayton Act was, I think, 1914. But basically, Section 1 and Section 2 are antitrust laws in this country. We don't have to go over Hart-Scott-Rodino, but if you want to file to become, merge with another company, these are the kinds of steps you have to go through, and they all take into account whether there's market power, where you're selling, what's the geographic market, what's the product market, what's the shares, and there's a mathematical formula that's used to determine whether if after you merge, you're just going to be too big. And if it looks like you're going to be too big, we're just going to prevent that merger. We're going to assume that's illegal. But I guess one point I just want to make is that, especially in this Google case, you can see it, that there's this tension between wanting companies to be competitive and not wanting them to take over the market. So in other words, the same kinds of sort of verbiage people use to say, we're going to go out and kill the competition means, in one context may mean, yeah, we're going to be really competitive, we're going to get those prices down. In another competition, it may mean we are trying to wipe out the competition, so we'll only be the only entity here. So that's the antitrust law. You don't have to take the class now. It's all done.
For all the students, appreciate you saving them time. That was an excellent overview. There's definitely a lot of depth there, and certainly we're glad to have your knowledge on the panel. Professor King,
okay. So to give you one very prominent recent example that especially the students would appreciate now, a horizontal agreement that the Justice Department has been in the process of settling over the last year or so has been with elite universities in financial aid, in which they all agreed together to adopt a certain set of formulas to determine how to award financial aid, which essentially led to uniform price fixing for financial aid packages. So no competition between these elite universities in the financial aid they offered because they agreed to the exact same formula and to comply with it, right? So someone should have told them, maybe their law faculty, that what they were doing was inappropriate. Right, so what we're talking about mostly in the Google case is, in this instance, vertical integration problems, right? We're talking about exclusive deals with Google, exclusive deals with Apple, exclusive deals with Mozilla, and any other provider of hardware or services that offer some search function. And before we get going, how many of you use a search engine other than Google? What do you use?
Bing's, Microsoft.
Bing, and we're actually going to probably see Bing increase over time. If any of you have been following the news, they're actually integrating a very powerful AI program. Right. Yeah. So right now, right, when we think of Google, it controls, depending on how you define the market, because another search engine that most law students use and lawyers, Westlaw, Lexis, right, they're not tied to Google at all or Bing. But what the Department of Justice argued is we're looking at a general search engine. So we're not looking at the search engine on Twitter or on Facebook. We're looking at general search engines. And when we define the market that way, it's pretty clear that Google owns that market, not in terms of property, but is the dominant search engine. So over 91% of people use Google over other search engines. The next closest is Bing, at 3.3% in the latest news. And of course, one of the major advocates in this case, in these cases against Google, has been DuckDuckGo, and their percentage is 0.5% of the entire market. So we're not talking about where Google clearly, if you're like me in this example in this audience, we use Google. And if you remember the early days of the internet, we use Google because it actually works. When the early days of the internet, search engines were very, very unreliable. The concern here, though, again, are these exclusive deals where Google becomes the default browser on your device or on your on your web browser. And so you may not even know this. So if you have an Apple phone, that is your search engine, and it doesn't necessarily say Google as you're doing this. Now, you can change this, and that's going to be something we'll talk about in a bit. The other side of this is not just these exclusive deals, But it was revealed in the trial that occurred this fall how much Google actually pays for this exclusivity as well, right? So one might say, hey, you are the dominant search engine. There's going to be a value to Apple and other companies just to use your service. But Google is also very competitive in other markets, and especially in this context, wanting to derive more revenue from its primary revenue base for search, advertising. So what do? They paid Apple, what we found out in the case, $18 billion essentially annually to be the exclusive web browser for Apple. They paid $26 billion total to all the other companies to be the exclusive provider. So that's essentially the concern, right? So the Department of Justice is worried that these exclusive deals making Google the default search engine is in fact causing monopoly issues and therefore stifling competition. Now, the primary case that both the Department of Justice and others have relied on, as Eric began us with, was this case from the 90s, back before there was much of an internet to speak of, and it involved Microsoft and Internet Explorer, which obviously doesn't exist anymore. I think it's now Edge, right? And another browser that most people in this room probably never heard of called Netscape. And Netscape was the primary competitor and alternative to the Internet Explorer. And so what was the problem, right? One, facially they're very similar. Microsoft entered into exclusive deals with PC manufacturers, distributors like Best Buy, to become the default browser. And not just the default browser, but the only browser, right? So when you bought your computer and it came with its package of software and services, your internet browser was Internet Explorer. Microsoft argued, especially on a Windows computer, this is a useful thing, you're getting that product for free. There are values to having two software packages from the same manufacturer, the same producer, because they can make it run more efficiently. And the argument was, look, if you want a different browser, you can download Netscape and you have it that way. Just the same way the argument from Google's perspective is, if you want a different browser, a different search engine, just change it. In fact, the other day I put in search engine as my search in Google, and the first thing was, here are the, I think, top 15 search engines other than Google. And that's through Google's own search engine. And so should this be kind of the equivalent? So the concern here, Microsoft at the time had 90% of the market for operating systems, right? So Windows was the dominant operating system. It is still the dominant operating system today, but the concern at that time wasn't just the operating system market, because like Google, you could argue it was the best at the time, or the most cost-effective at the time. Just imagine the difference, or you can still see it today, the difference between the prices for Windows devices, Android devices, versus Apple devices. There tends to be a premium paid for Apple, which even back then was Microsoft's primary competitor. So this idea of exclusivity was a concern, but the case ultimately turned on more than just exclusivity, which is why I would suggest that it's actually a very bad precedent compared to what Google is doing now, which what I would suggest is they're the best search engine out there, and if they want to subsidize our ability to access the search engine by paying Apple and other services, that's what being a good business is, right? The concern was with Microsoft, they also had two other major problems. One, they integrated the web browser with the operating system. What does that mean? It's not just simply that on your desktop there's Internet Explorer and it operates with Windows. It was that, for example, if you tried to delete the Internet Explorer, they designed the operating system in a way that you could not actually delete it through the add and delete function that you could use for every other app that you could use on Windows. And now that could be a minor inconvenience, right? So you have this program still sitting on your hard drive. The next thing they also did, right, was if you actually deleted the Internet Explorer app, your Windows operating system could crash. Right? So what they essentially did was take part of the program code for running the computer itself, the operating system, and put it into Internet Explorer, right, which is a separate application. But by integrating the two, Microsoft said that there were efficiencies with which the browser would work, but of course it also meant if you now get rid of the browser under these circumstances, you've ruined and essentially made your Windows computer useless. Again, maybe not as much of a problem here because you can still keep Internet Explorer out there. So this leads to actually the most important point about the Microsoft case. For those of us who study technology law and do especially internet law, for people who do competition law and antitrust law, Microsoft was one of the first cases where they were introducing the problem of network effects. And that is the basic problem in certain markets. The value of the goods or service is dependent on the number of people that adopt that good and service, right? And the value increases the more people adopt it. Now, of course, there is a problem with human behavior, which is once we've adopted a good or service, it's very difficult for us to change, and especially if our value in that good and service is based upon the number of people that use it. Any of you who've experienced the problem with social media, I want to get off of Facebook or I want to stop using Twitter, not that just to do it in general, which I highly recommend, unplug, it is a very important, healthy thing to do, but that I want to switch to an alternative service. Good luck, right? Good luck finding a social media program like a Facebook that provides you with the same network of family, friends, associates, and news sources that you had from Facebook. Because getting people to move in large scale is a very difficult thing to do. And so Microsoft, in this case, was relying on that fact because its ownership of essentially the market for operating systems gave it a huge competitive advantage in another area, and that is software. Any video gamers in the audience? Wow, okay, people who don't want to recognize that they're video gamers, right? I'm a video gamer. Anyone who actually ever went to a physical shop for software would know that you go into this shop and the number of video games available for Windows computers was essentially the shop, and then the kind of shelf space for Mac computers, Apple computers was maybe a tiny little row of software packages. And for Microsoft, this was a huge advantage. Because of the 90% market share, software providers would first create for Microsoft computers. And that means when I'm in the market to buy a computer, I'm going to buy, most likely, a computer that is running the Windows operating system, if I want the largest software package and choices possible. So, who cares, right? Why is this a problem? If you're like me, you buy Macs anyway because they don't crash. But even if I can't play the video games I might want. But the concern here was Netscape. And Netscape was a different kind of browser before we had cloud computing or web-based apps. And so Netscape was important in the sense that it now was possible through this browser and through the internet to provide those apps that Microsoft essentially had 90% share controlling without having to run a Windows computer. Think of Netscape as the portal or the translator that now made so many of these opportunities potentially available on an Apple computer, a Linux computer, or any computer running any operating system other than Microsoft. Right? So this opens the potential doorway to a very serious amount of competition that not only threatens web browsing, but fundamentally threatens Microsoft's fundamental business model of operating systems at the time. That's the theory ultimately that led to the settlements and the Microsoft case. So is that what's happening in Google? And one, we don't see any integration problems. Right? An example of that might be if you're using Chrome, and in Chrome you try to use Bing, and now all of a sudden you can't get to Bing, right? Or your web browser crashes because you're trying to use Bing. And that's not the case, right? Again, through Google itself, you can get to Bing or GoDaddy or any other service like even Baidu in China. Right? So we don't have that integration problem. Plus, there is no other market that Google is trying to necessarily leverage here. Like Google, Apple, Microsoft, all these companies are in serious competition outside of this realm, right? And as I suggested earlier, AI is probably the most important service that they are competing in. And in fact, Microsoft had recently overtook Apple in market share and price, in part because of its AI investment. Right? And this is something that you wouldn't have anticipated back then. Right? So is this the same, or is it just Google being the better product? I tend to think it is Google just being the better product because there's so many differences between those two.
Thanks, Ray. That was wonderful. With the exception of you made me feel old about what you said about Netscape and people not remembering it.
Oh, I'm much older than that. So.
Remember it fondly. And now, whenever you're ready.
Thank you. So first, I just quickly want to ask, who's using ChatGPT? Chat. Okay. I had to ask my kids to teach me how to use that. Okay. And the point is, so I used to also think about 2 years ago, right, that Google dominated over 92% of the market. But now I think that we're finally having some serious competition thanks to AI. And I think we're going to continue to see that growing. What I wanted to do is actually show things from a little bit of a different perspective, kind of in a macro level. So I actually come from the corporate world, M&A. I used to do mergers and acquisitions. I used to represent tech companies, so I'll focus on the tech side a little bit. And to me, well, I practiced a long time ago, but when I used to practice, we didn't even discuss antitrust. I mean, yes, it was always in the background when you're structuring a certain deal. Usually you're thinking about, okay, it needs to be clear, you structure in a way, and I'll talk about that too, to avoid antitrust review, and I'll talk about some of so that's how I look at that stuff, from the structural perspective of what are some of the new tricks that they're using, or I think that they are, to avoid that review. But also, and that's something that I tell my students, I also think I'm also going to raise some high-level questions. As a society, I think we need to kind of decide, how do we want to look at this? And I always think about it from an innovation and entrepreneurship policy perspective, as a national policy perspective, right? Because I look at what some of these companies that were discussed, and I'll mention a few more, just like an infrastructure. Think about it. We're here in Cleveland, right? And we've had, historically, some of the first companies that created the big monopolies, the infrastructure that they built, and some of these big tech companies. And by the way, today there was a congressional hearing, right? There was a congressional hearing. Meta was there, Mark Zuckerberg, about privacy. So there's so many issues, and I feel like big tech is under attack, and we should really think about, on the one hand, we have this infrastructure. Think about the connectivity that they provide. On the other, they're under attack of being a monopoly, but we have to ask ourselves, do we want this infrastructure? Do we not want this infrastructure? Because one thing is very clear in tech, and that is very few companies, and usually the tiny ones, the very small ones, are the ones that innovate. The big companies, the ones that can really do the scale, what they do is they just acquire others. I used to do that, right? I used to represent the companies that would acquire the others. And by the way, that's why today we still have, for example, unicorns. Unicorns, yes, they're tech companies, they're huge, they're staying private longer, but they also acquire other firms. Okay, so that's the thing. Do we want to jeopardize, on the one hand, acquisition? At my time, when I practiced, I mean, the M&A was booming. We were doing a ton of deals. Today, I know from friends who are still practicing, unfortunately, not so many deals. And there's different factors that contribute to this, but we really have to think about, is that going to hurt our innovation? And if we and I also hear breaking up the companies, and I ask myself, how are you going to break them up? And what's going to be the price that we will have to pay for breaking them up? Are you sure you want to break them up? Now, I'm not saying everything they're doing is correct, and now we'll go into the details. But think, what is it that bothers us? Is it the price? Is it the privacy concerns? Can we deal with some of these issues? What are the alternatives? And also think about it in terms of a national policy, because we are competing with other countries, and that is true. Okay, and we have more laws and regulations than other places. And that's why in some of the fields, I feel like other places have a leg up. Because they don't have the same restrictions that we have here. So let's kind of quickly, I want to raise a few things, and that is, for example, with Google, right? Because we started with Google. And if you think about the CEO of Google, I'll just start a little bit with the CEOs, right? And the other big tech companies. So we have Sundar Pichai is the CEO of Google. We have Meta, Facebook's Mark Zuckerberg, Amazon's Jeff Bezos, Tim Cook, right, of Apple, and others. And they're considered the leaders of the free world, right? And some people are saying that they're holding all these strings through things that, by the way, we already have on the books, like interlocking directorates, right? So we actually have, if we're really concerned about antitrust, there are some laws that we have that maybe regulators can start enforcing, and then depending on what. Let me give you an example of why connections, though, on the other hand, are important. Let's go back, because I looked at Google before I did an IPO. And I checked, and I wanted to see who was sitting on the board, because I know I used to represent these companies. And guess what? You want powerful people on your board before you do an IPO. You want to benefit from their knowledge. You want to use their connections. You want to use their networks. So like I said, there's always two sides of the coin. What is it that we want to do as a society? So when I looked at Google, for example, I saw that it was connected with both firms in Silicon Valley and outside of Silicon Valley. And let me give you examples. In Silicon Valley, we had the CEOs of Apple, Cisco, eBay, Intel, and Yahoo sitting on the board of Google before it went public. Okay? Now, let's talk about the network and connectivity outside of Silicon Valley. Okay? We had, guess, Walmart, Amazon, okay? Google didn't become Google in magic. Okay? You have to understand there's a way, and again, I'm looking at it from the corporate perspective because I used to represent these companies, that you need those connections. So that's what I said, we always need to think about the two sides of the coin. Do we want this service? Do we want this infrastructure, or we don't want this infrastructure? And what are we concerned about? Okay? By the way, interlocking, I didn't explain. Justice Brandeis talked about it. It's a practice where you have an individual that's a member of two or more companies, and they're sitting on the board of directors. Okay, so basically they're a director, and that's how you have this flow of information, okay, between companies. That's how companies share information. Now, lately I've also heard some discussion and concern. One of the concerns is that we have these new actors, and some people call them net states. So they are concerned that these companies have accumulated so much power that they are more powerful than states. That's why they call them net states. Okay? So like I said, again, what is it that you are concerned about? Are you concerned about the price? Are you concerned about their political power? And I think as scholars and also policymakers, you have to think about what is it that concerns you. And then there are concerns by some scholars that perhaps some of that power accumulation and capital accumulation also threatens our democratic institutions. And then we have to ask ourselves, do we agree with that? Do we not agree with that? Why? Another thing that I noticed, let's also talk just briefly about the fact that we know with this administration, for example, from the beginning, we knew that they're going to be tough on M&A, right? They're going to be tough on mergers, and they're going to scrutinize more what's going on with regards to these types of acquisitions. And so what I've been noticing is that perhaps we have other ways of accomplishing the same results. For example, I don't know how many of you are following, and now the administration said they're going to take a look at this. Let me just pick OpenAI, for example, right? I looked at their governance structure and I was like, this is disastrous, okay? Before even all the news broke on the way they structured it. And I'm sure you know that Microsoft invested a lot of money. And what did they do? When they invested all this money, they took an observatory board seat, not even a regular board seat. Now, there could be several reasons for that. But then I'm going to ask my colleagues, perhaps one of that reasons is antitrust, right? They're not. They don't. They get the information rights, but they don't have voting rights.
So regulatory avoidance.
Yes. Okay? So that could be one of the reasons. And there's other instances, for example, corporate venture capital. So a lot of the large big tech companies have venture arms that I've been also following. And what they do is they invest in multiple companies, just like VCs, venture capitalists, but they invest for different reasons. So they don't invest to make a buck. Like when a VC invests in a company, right? They do that to make money. These corporate venture capital arms, when they invest, they usually invest, just like VCs, in several companies from the same industry, but what they want to do is, by the way, Ed Herrera from Yale and others have this paper on killer acquisitions. They want to decide, am I going to take over this company? So I'm going to invest in a few companies, and I'm going to decide at the end which one I'm going to kill or which one I'm going to acquire, and the rest I'll decide what to do with them as well. Right? So all these new phenomena that we should take into account. Another one is, for example, SPACs. Some of these firms, because they weren't able to, they didn't want to take direct board seats, or the company still needed money and they invested in them, perhaps helped them, and they sponsored the SPAC. You know what's a SPAC? It's a special purpose acquisition vehicle where you can just go public with merging with a public company. And what's the advantage of that? You can do that very quickly, and the company can get the influx of capital that the big tech perhaps is afraid to give them because of antitrust review, and then the company gets the liquidity, you still get information rights, and everybody benefits, and you sponsor the pipe. So there's all these things that we're seeing. There could be as a result of some of the dynamics in the market. But my point is that it's not easy. It's very hard, and we should really think about, as a society, what is it that we want to promote, right? What is it that's important to us, and how are we going to continue from here? Because I do have a little bit of criticism, and that is, even if we look at the oil companies, after they broke them up, right? What happened? It was the same players who controlled all those other entities at the end and even made more money. Okay? So that's what I'm always saying. What is it that we want to do? I think, and those are difficult questions, I know, but I'm hoping we can kind of start opening up the discussion with that regards. Thank you.
So we have some time for questions. See a hand here. There's a microphone that's coming around. If you wait for it to arrive.
Hi. So to be transparent, I took antitrust with Professor Bryce last semester, so I think I know more than I actually know. To preface this question, so I think Professor Koo, you mentioned that in your opinion, Google isn't really trying to move into other markets. It's
Okay. Google is an operating system now, hardware manufacturer, all sorts of.
Okay, then I misunderstood. I was kind of wondering what you thought about things like Google Home, or the fact that Google is creating like cell phones, and if you think they're doing that in order to use their market power in the search engine to then, like, what if now on their phones that's the only way that you can use Google, like they take it off of Apple completely?
Yeah, and that would be the anti-competitive concern here, right? Because there's nothing wrong with companies beginning with a single or special product and service and then expanding and diversifying. Right? The old school General Electric is an example of a company that had its fingers in all sorts of different pies in the industrial age, right? Microsoft, Apple, Meta, you name the tech company today. You can identify probably their business of origin, but you probably have a very difficult time ending the list of other businesses and services they are involved with. And they are competing very vigorously, sometimes in cooperation, forming different little ventures together, but there's serious competition in the AI market, the hardware market, for all sorts of devices, right? We go from computers to smartphones. Microsoft's biggest failure was to not see the smartphone market as important as Apple did. Home security and home integration is one of those newer markets. And full disclosure, my sister works for Amazon and my brother-in-law works for Google. Right? And, but they're doing different parts, including graphics chips, right? So they do even very traditional technologies as well as these new ones. And again, the integration of operating systems, the ability of these devices to communicate together has fantastic opportunities and benefits to consumers. Right? But what are they doing anything beyond simply providing a better product and service in a competitive market, right? Because Professor Beck asked, what are we focusing on? And in this context, you had it up on your slide, right? Antitrust law and competition law protects competition. It doesn't protect competitors. If you are the best search engine, sorry if GoDaddy only has 0.5% of the market share, right? That's just the way it is. Because we want the better product and service or the product that's offered at a better price point.
Thank you for the presentation. I had a question with regards to the pre-competition, what you were alluding to of antitrust is protecting competition. So with regards to like something where an AWS or a autonomous delivery system or something that tech is doing that's not yet on the market yet, they've scooped up all the talent because they have the biggest payrolls, and so therefore when it does go public or the services available for the general public, there is no competition. How does that play out, recognizing that this is happening before it is even going live?
So you want to start since kind of what you're talking about with the way corporations are structured and then the acquisitions?
So I'll be honest with you. I'll tell you what bothers me with regards to that, and that is that we've got some structural changes in our financial markets. So again, if I'm kind of looking at it in the macro level, my concern is that our public markets are actually shrinking and our private markets are growing. And luckily for me, I'm writing about it, but I'll tell you why I'm concerned. And that is in the past, right? Let's say, forget about big tech. If you're a small startup and you would be, let's say you're lucky, and very few are because 90% fail. But let's say you're in one of the top, 10% that's going to be successful. According to research, empirical research from Jay Ritter from the University of Florida, within 4 years you're going to do an IPO. Why? Because you're going to need the liquidity. Now, why is an IPO important? Let me just explain. Why is an IPO important? Because when you do that IPO, what it allows is the old talent, part of the founding groups, okay, to leave and start their own ventures. And then we have this, what we call knowledge spillover, okay? The problem is when these companies are now, according to my research, staying private for longer than 11 years, you think about people are not leaving, especially those that I want them to leave, which is the old talent, the talent that contributed to this. You know who's leaving? The new hires, the ones that I barely even educated as to what is the company doing because they're diversifying their portfolio. Those are the ones that I want to stay. The ones that I want to leave are the earlier ones because I want them to go compete and start their own companies. And what's happening is they're not doing that enough. Okay, so we have issues in the market that we should really take into account because that also affects competition. So like I said, this is really, it's a very difficult question. Also, acquisitions, the fact we don't have enough M&A, I'm sorry, I see it as a problem. But I'm biased. I was an M&A attorney, okay? So I consider that as an issue. It's a serious issue. Why? Because why would I represent these companies? I used to represent these companies because somebody has the technology, the other one has the capabilities of scale, and we want that, okay? We want that. We want to grow certain companies. And so I'm also worried about that. But those are just some of the things that I think are problematic that we're witnessing, and we're going to continue to witness. And also, we don't want our public markets to weaken, because think about that. We have some of the best we have the best efficient public markets in the world. And so what's happening when those are shrinking, or if investor confidence in them is not what it used to be? To me, that's problematic long term, and I like to think long term. Thank you.
I just want to address your question. I think what you're saying is that these tech companies kind of scoop up a lot of talent, and then it's too late. So I just want to give you a couple of examples. The law allows for the government to come in and say, we're going to break you up, or even if we've already approved an acquisition, we can reverse that. So I'll just give you two examples. One's a very old case. AT&T, the government broke up AT&T. So we had one phone company in this country, and it was broken up into the bells, and they were referred to as the baby bells. And then the technology in phones really evolved, and there is competition among phone manufacturers. Another example is Facebook. So the FTC has sued Facebook, claiming that they've been anti-competitive, wanting to create a monopoly by acquiring Instagram and WhatsApp, which the FTC approved. They're acquiring at the time, but now they're saying, that was with intent to be anti-competitive. So it's not. I guess what I'm saying is, once you get big, it's not the end of the story necessarily. Yeah.
And the competition over employees and talent is always part of every business. And then from an employee's perspective, you like the kind of existence of this, these companies with large amounts of resources and huge revenue and the ability to turn around and pay you. And yes, there's a lot of competition in employment there. With my friends and family, their average stay at some of these places is ridiculously short. But the way that traditionally that's been responded to in Silicon Valley and tech in general has been, we may not be able to offer you the cash compensation that Google might. Or back in the 90s when I made one of the most foolish decisions of my financial life, which was I was looking at work as a programmer for Microsoft in 1990. And I was I don't want to write word processing and spreadsheet programs for the rest of my life. Little did I know that Windows 95 was going to be down the pipeline and turn Microsoft into the kind of company that made their custodial staff millionaires. Right? Stock options, equity ownership, right? And so startups, that was and still is a very major part of recruiting. So if I'm willing to take the risk, I'm not so concerned about that steady paycheck if I might be able to retire after a couple of years because I picked the right winner. Now, what Professor Beck is describing is the part that threatens that, right? To the extent that these companies are now using positions in boards to potentially squash that kind of competition, then that labor market becomes much more dangerous.
And we're seeing it now. I mean, that's what we're dealing with now.
Hi. So my question is specifically like the Google litigation. Like you're saying, Professor Koo, that like the network effect is obviously very large there. How do you think the litigation is going to get over the fact that the Supreme Court in the American Express case said that the advertisement through newspapers doesn't get that sort of, analysis? Like, how do you think that's going to affect the litigation, and how are they going to talk about the network effects?
Well, what I think is interesting about the Google search engine problem is I don't really see the network effect. Right? If I want, I can change the default engine immediately. right? Or as I said, I can use the engine to, in fact, get to the alternative engine, right? And the value of using Google isn't the fact that everyone else uses Google. It's that Google gives me better search results than some alternative. I think the really fascinating questions that are coming out both in the European Union and in the US today, and even against Google, are the efforts of all these companies to create their own little marketplaces, right? So the Apple Store, the Android Store, and how the concerns about that degree of exclusivity is raising anti-competitive concerns, right? And Apple forever has argued, and it's an argument that I actually agree with, that their overall control, essentially in their way of viewing vertical integration, including what services and products are available on their store, is important to, one, promote the issues they care about. Right? So if they care about privacy, they're going to take steps to ensure that a product that was a software that ends up on an Apple device complies with their policy considerations for privacy. They want their devices to function. How many times do you have your iPhone or your MacBook crash, right, or your iPad crash and require you to reset it? But if you're a Windows user, you all know Control Delete rather perhaps by reflex, right? I mean, there's an issue about this degree of control, and there can be very important benefits. So the idea that it's efficient for Apple to limit the amount of access to their devices, or the alternative, it certainly stifles potential innovation. Right? There are fewer products now available on Apple than it would be on an Android phone, or on, I forgot what the Windows old OS was for phones. And we're going to actually see a real-life test of this, right? Because network effects is a theory, right? It's a theory about how markets might be influenced by that economic theory, or that descriptive part of human behavior. This idea of walled gardens versus more open gardens are theories of competition. And because of what the European Union is doing, if you follow the news, they are now requiring Apple to open up their store, and so you can essentially now buy software and other apps outside of the traditional Apple world. Right? Is this going to improve the products offered on Apple, or will it lead to more Apple iPhones crashing or iPads crashing? Will it lead to more data breaches? And so we'll actually have an empirical test of which of these theories might actually have some validity in the world. Or, as Professor Beck suggests, maybe we break up these things and they essentially all go back to where they were in the first place, right? Microsoft was looked at in the 90s. Microsoft is still one of the dominant computer and software manufacturers in the world today. Now, it might be for different reasons, right? Because they continue to innovate. I do think like the internet today would look very different if Microsoft had won in the 90s. There'd be less. Google found its way into the market in part because of the antitrust case against Microsoft. They became not just a search engine, they became a browser, they became an operating system as well.
I want to say one thing about some of the things we talked about Google. I think that to be a competitor to Google is almost insurmountable now.
Yeah.
Okay, and I think there should be competition. I don't have a sort of agnostic about what happens to Google, but just because they're good, it needs to be addressed. Like, there's not their agreements do foreclose competition. When you pay somebody $18 billion, well, that's the end of competition. There's not going to be any competition there. And so I think that's what the court is struggling with, because Google has been very innovative on the one hand, but then how are we going to? And you shouldn't. They came up with this code, this free code. That's how Androids came about. Now they're saying you can't use that code, you can't change that code. You can't use the interface, and so what we're in a situation where there's no way to compete with this hugely powerful worldwide organization, And these, Microsoft is huge and they're not able to do it. So what's the answer to that? And I'm really curious to see what this Judge Mehta in DC comes up with for the answer to that.
So let's take one last question.
Yeah, the panel has described the current administration's enforcement approach as tough. Could you maybe give us a couple of the attributes, the significant attributes of why you say it's tough as opposed compared to prior administrations?
Well, I can tell you a little bit about, as an example, merger guidelines. So when you say tough, I think that they brought some cases that maybe wouldn't have been brought. They haven't won some of those cases. But for instance, there's vertical and horizontal merger guidelines. And horizontal merger guidelines recognize the fact that you can figure out what market power is, what market share is. Hard to do with vertical. They're not in the same market, right? That's the traditional two guidelines. And there's also a threshold in those guidelines that say if your market is this big, if you have this much market share, you're too big. We're not going to let you merge. So recently, the FTC and the DOJ Antitrust Division came up with new guidelines. And those guidelines say we're going to judge these all under one roof. We're not going to look at vertical and horizontal differently. And that threshold for, your market share, if your market share is 60%, let's just throw out that number. I can't exactly tell you, it's a Herfindahl index number. And previously, if it's 60%, then we're going to be concerned. Now they're saying, well, maybe it's 35 or 40% and we're going to be concerned. That's an example of what I don't use that word tough, but I guess that's tougher if you're trying to merge, right?
And that came as a shock in Silicon Valley because you have to understand, Silicon Valley, most of the integration you're going to see is vertical, okay? And so and we can see less deals. I mean, I know my friends, they're doing less deals. We have less deals as a result. But again, I'm not going to go over what's good or bad in terms of policy. I'll leave it up to you two, or the antitrust experts. I just see from a corporate perspective, and I'm raising it from a corporate perspective, that there is concern. There is concern among practitioners, among business people with regards to that.
And philosophically, right, we've kind of seen what you can describe as three different mindsets. Right? The original anti-monopoly, pro-competition model would have said we want competition at every single level, every single part of the market, right? So including vertical integration. And so if I am the raw materials producer, we want competition even in the hauling of that raw material to the refiners and so on, because that could have significant benefits to the entire market. Right? We're going to hopefully have businesses that are, in the traditional economic terms, providing better quality at a better price. And then we went through a philosophical shift where, especially in the vertical integration context, that's not a big deal, right? We can see the efficiencies there. Or then the idea that even monopolies themselves aren't inherently bad for the public, right? Because it prevents duplicative investments in resources and therefore waste. There are efficiencies with essentially a monopolist that aren't there necessarily with competition. And so for, I would say, beginning kind of with the Reagan administration, in the 80s, there was much more of a hands-off approach on those mergers as well as competitive deals. Right? So price fixing obviously became the clearest example that everyone had a problem with. But other arrangements were more acceptable. I think big tech has kind of added a third area here. And it's the concern of what people see as the dominance of a handful of companies that can then have very quickly control over all sorts of aspects of our digital life. I would suggest that yes, that's a concern. I'm a lot more agnostic than some of my academic colleagues. I'm a big proponent of the economist Joseph Schumpeter, which is that we can rely on anti-competition and anti-monopoly laws to deal with some of these concerns. But the biggest kind of part of competition and innovation comes by technologies that make the prior technologies essentially worthless and replace them. Right? So it's not that copper wire became better and more competitive because we broke up the Bell Company, but because we went to mobile phones. It's not that Yahoo lost its competitive advantage because of this upstart venture company called Google came around. It's because Google created a better software system, and that's when I went to the comment about Bing. Bing and Microsoft, because of their relationship to OpenAI and ChatGPT, might replace Google in that sense, right? So instead of search and search algorithms, artificial intelligence. Now, of course, the one thing we should all be concerned about here, and it goes back to some of the other questions, is all of these companies are using all of these products to gather every bit of information about all of us as much as they can. And they're using that market power and that position to gather that data. And our ability to kind of opt out or find different tools is much more difficult in that sphere than, for example, changing my web browser or changing my search engine.
That's why they're using antitrust. Sometimes I criticize and say, well, wait a minute. If you want to deal with privacy, why are you using antitrust? I mean, that's to me sometimes the excuse of using antitrust tools, right?
Yeah,
because they can't deal with that privacy, so they're using other tools. But this is not about antitrust.
Antitrust has no effect on your data privacy. No
Exactly.
cases.
This makes me wish we would have done symposium rather than. Please join me in thanking the speakers for.
Thank you.